The government violated the plea agreement in two separate and significant ways. First, it invoked a carve-out provision to avoid a base offense level it had deliberately agreed to, based on a prior conviction it had known about since the indictment was filed and had explicitly referenced within the plea agreement itself. Second, it recommended a multi-count upward sentencing adjustment that it had directly told defense counsel would not apply. The government's own opposition filing confirms both of these violations while introducing a brand new legal theory, one that, by its own admission, nobody caught when the sentencing documents were submitted, in an attempt to cover up the damage its breaches caused. In today's video, we're breaking down exactly what happened. Probation didn't catch it, the federal prosecutors didn't catch it, Brick's own lawyers didn't catch it, but somehow everyone expected Bricc to just accept the consequences. This situation is about to get deep. The government's opposition doesn't actually disprove the breach, it proves it. In trying to defend its departure from the agreed sentencing framework, the government's response reveals three critical things. One, its use of the carve-out was based on a prior conviction that was listed directly on the face of the indictment and explicitly incorporated into the plea agreement from the start. Two, its sentencing memorandum recommended a +2 multi-count upward adjustment under USSG 3D 1.4, the very same adjustment its own pre-plea email told defense counsel would not apply. 3. The analytical framework it now uses to justify a total offense level of 23, specifically 3D 1.2D grouping followed by 3D 1.3B aggregation, appears nowhere in the sentencing memorandum. And in a footnote, the government essentially admits this was a theory that both the probation office and all parties missed entirely before sentencing filings were submitted. That last concession is the most important one when it comes to prejudice. The government is asking this court to find that Mr. Mitchell suffered no harm because a newly surfaced after-the-fact legal theory that no one had identified at the time of sentencing just happens to arrive at the same offense level as the flawed calculation it actually presented to the court. But that's not how the prejudice analysis works. The question isn't whether the government can reconstruct an alternative path to the same number after the fact. The question, under Santabello v. New York, is whether Mr. Mitchell's decision to plead guilty rested to a significant degree on the government's representations, and whether the government honored those representations as agreed. Mr. Mitchell entered his guilty plea with a clear understanding. His total offense level would be 19. The government told him so in writing before he signed. The plea agreement's carve-out was never designed and cannot reasonably be interpreted to allow the government to retroactively reclassify a conviction it had possessed from the very beginning of the case. The sentencing memorandum then recommended a multi-count upward adjustment the government had explicitly said would not apply. Those are two independent breaches. The government's opposition provides no real answer to either one. The motion should be granted. In plain terms, the government knew about this conviction before the deal was ever written. They drafted the plea agreement around it, both sides signed off, and probation signed off too. That was supposed to be the agreement. And then the government broke that agreement in not one but two distinct ways. It's like agreeing on the exact terms of a deal, shaking hands, and then the other party turns around and says, actually, we're changing the terms, and comes back with two separate reasons why the original agreement no longer applies. You genuinely cannot make this up. The government conducted all of that research, reviewed all of the relevant prior convictions, concluded the plea deal was valid, put it in writing, signed it, and then turned around and said the deal needed to be revised because they had supposedly overlooked something. That's like selling something at an agreed price, having the buyer sign the contract, and then coming back weeks later saying, actually, we realized it's worth more, so you owe us extra. That's not how binding agreements work. Let's keep going. The government breached the plea agreement by recommending a multi-count upward adjustment in direct contradiction to its own pre-plea representations. The government tries to frame the July 17th email as nothing more than a rough estimate, something non-binding under prior case law, but then, in that same opposition, acknowledges that the email's prediction about the multi-count adjustment has actually turned out to be correct. No upward adjustment should have been applied. Yet the government's own sentencing memorandum recommended exactly that, a +2 multi-count upward adjustment. So the government is now telling the court that its pre-plea representation was accurate, while simultaneously having submitted a sentencing memorandum that recommended the opposite. That contradiction is the breach, not what the government says now in its opposition, but what it actually filed with this court. The government's reliance on United States v. Bench is misplaced. That case addressed the narrow issue of whether the government was obligated to affirmatively advocate for a sentencing recommendation it had agreed to make, not merely recite. It did not address whether a pre-plea representation about how the guidelines would be calculated, made in direct response to a question from defense counsel before the defendant signed, could form part of the inducement for the guilty plea under Santabello, and it can. When a plea rests to any significant degree on a promise or agreement made by the prosecutor, that promise must be fulfilled. If you signed it, you're bound to it. Defense counsel directly asked how the multiple categories of conduct in the plea agreement would be grouped for guideline purposes, and what the resulting total offense level would be. The government answered, the total offense level would be 19, and there would be no upward adjustment for multiple counts because the other counts were too low in value. Mr. Mitchell understood that, relied on it, and signed the agreement. Then the sentencing memorandum said the exact opposite. That discrepancy isn't a question of estimate versus promise. It is a material representation made to induce a guilty plea, followed by conduct that directly contradicted it.
The government also argues that the integration clause in paragraph 28 of the plea agreement blocks any reliance on the July 17th email, but the parole evidence rule does not bar extrinsic evidence offered to resolve an existing ambiguity within a contract term. It only bars evidence offered to introduce entirely new terms into a fully integrated agreement. The July 17th email is not being offered to add something new. It is being offered to show what both parties understood paragraph 12's grouping provisions to mean at the time Mr. Mitchell signed, specifically whether the multiple categories of conduct would trigger a 3D 1.4 upward adjustment. That is not a new promise being imported from outside the agreement. It is evidence of how the existing sentencing framework was mutually understood to operate. Extrinsic evidence bearing on that shared understanding is properly considered by the court. The defense's argument is straightforward. They asked the government directly about the grouping calculation before signing. The government said not to worry about it. The numbers worked out, no upward adjustment would apply, everything was fine. The defense confirmed it, the government confirmed it, and then everyone signed. And now the government is pretending that conversation never bound them to anything. This is genuinely troubling. It's hard to understand why the court didn't look at this and immediately conclude that the government fell short of its obligations. At a minimum, Mr. Mitchell should be receiving the benefit of what he actually bargained for. Mr. Mitchell was directly harmed by the government's breach. He entered the plea agreement with a clear understanding that his total offense level would be 19, which would have produced a guidelines range of approximately 57 to 71 months at criminal history category 5, or 63 to 78 months at category 6. The government is now seeking a range of 92 to 115 months, more than 30 months above the top of what Mr. Mitchell understood he was facing, and nearly double the low end he had agreed to. That gap isn't abstract. It flows directly from two independent breaches: the carve-out invocation that substituted a base offense level of 20 for the agreed-upon level of 14 on the shell company count, and the multi-count adjustment that directly contradicted the government's own pre-plea representation. The government argues that Mr. Mitchell suffered no prejudice because the other benefits of the plea agreement, dismissal of count 1, no fraud superseder, and the non-prosecution agreement all remained intact. But Mr. Mitchell bargained for those benefits within a specific sentencing framework. The government cannot strip away the sentencing component of that deal while pointing to the remaining benefits and then ask the court to sentence him as though he had been convicted on all three charges. A breach is not excused simply because the breaching party honored other parts of the same contract. The government also points to paragraph 27, which acknowledges that no one can make a binding prediction about the ultimate sentence a defendant will receive. That provision speaks to the final disposition, the sentence the court ultimately imposes after weighing all the factors under 18 U.S.C. section 3553A, which of course neither party can control at the time of signing. It does not give the government license to misrepresent how the guidelines themselves would be calculated before the defendant decides whether to plead guilty at all.
That provision does not give the government the authority to recommend a guidelines range that directly contradicts its own pre-plea representations about how those guidelines would be calculated. Nor does it give the government permission to pursue a different range than the one it agreed to when it made its original offer to Mr. Mitchell. The agreed-upon guidelines framework is a separate matter from the court's ultimate sentencing discretion, and paragraph 27 does not override paragraph 12. To put it plainly, the plea agreement was structured around a much lower sentencing range. We're talking roughly 5 to 8 years, and now the government is pushing for 10 to 12. That's a massive difference. And for the court to accept the original deal, the judge had to look at it and think, this is a reasonable agreement. Why would the government offer this? The answer is, they had already reviewed all the evidence. They had been asked specific questions about the calculations before anyone signed, and they said everything checked out. That's the whole problem here. The government had years to review this indictment, was asked directly about the grouping methodology before the agreement was executed, said it was fine, and now they want to walk it back. The government's newly invented theory does not fix the breach, not even close. The government's primary argument on prejudice is that even using the plea agreement's own agreed base offense level without invoking the carve-out at all, a grouping followed by aggregation analysis independently produces a total offense level of 23. That argument fails for two reasons that have nothing to do with whether the government's math is correct. The breach happened the moment the sentencing memorandum was filed. It cannot be undone by a theory the government came up with afterward. That framework appears nowhere in the government's sentencing memorandum. The memorandum adopted the probation office's separate group methodology and recommended a +2 multi-count upward adjustment under 3D 1.4, the exact opposite of what the government had told defense counsel would apply. Now, in its opposition brief, the government quietly abandons that methodology entirely and substitutes a brand new one, introduced for the first time in response to Mr. Mitchell's breach motion. Case law forecloses this maneuver directly. A breach cannot be cured by later mitigation because there is simply no way to calculate how the government's error may have shaped the sentencing judge's perception. The breach is measured at the moment the government submitted a sentencing memorandum that contradicted its own pre-plea representations, not at whatever point in time the government manages to identify an alternative path to the same number. Whether or not 3D 1.3b independently supports a total offense level of 23 is beside the point. The government cannot retroactively fix a breach by showing that a different analytical route, one it never presented to the court, would have arrived at the same destination. And the principle goes even further than the government's opposition acknowledges.
Even an explicit, on-the-record retraction of an erroneous recommendation made before sentencing is insufficient to cure a plea agreement breach at that late stage. If walking something back in open court before sentencing isn't enough to undo the harm, then identifying an alternative framework for the first time in an opposition brief is plainly insufficient as well. The bottom line, you don't get to agree to a set of rules, break those rules, and then introduce entirely new rules to justify the outcome after the fact. The original agreement stands, and the government is bound by it. The government's own footnote admission destroys its prejudice argument. The government concedes that both the probation office and all parties missed the relevant grouping rule in the sentencing filings. That concession is fatal to its position. The prejudice analysis under Santabello is backward-looking. Did Mr. Mitchell's decision to plead guilty rest to a significant degree on the government's representations? It did. The government told him his total offense level would be 19. Its sentencing memorandum pushed for 23, through a methodology that, by the government's own admission, no one had identified at the time. Mr. Mitchell could not possibly have anticipated a framework that the government, the probation office, and defense counsel all failed to catch. Instead, he waived his right to trial, admitted to uncharged fraud conduct, and agreed to a broad appellate waiver, all based on representations the government then walked away from. Now the government wants to add years to his sentence based on a guidelines range that was never part of what he agreed to, and it's asking him to absorb the consequences of a calculation that no one disclosed to him before he signed. That is the definition of prejudice. Santabello prohibits exactly this. The government's no prejudice argument depends entirely on a theory it concedes was invisible to everyone until after Mr. Mitchell's breach motion was filed. The alternative theory doesn't cure the breach, it makes it worse. Think about what's actually happening here. The government is essentially introducing new rules after the game already ended. It's like growing up playing basketball, and then someone suddenly tries to enforce a rule that nobody ever called before. And when you push back, they say, well, technically it's always been in the rulebook. That's not how any of this is supposed to work. You play by the rules that were in effect when the game was being played. And this is exactly why you can't just take what the government presents at face value. We've seen it before. Multiple high-profile cases where the terms of an agreement didn't end up meaning what the defendant was told they meant. The government had this paperwork for years, was asked directly about specific provisions before anyone signed, confirmed everything was in order, and then turned around and tried to reframe the entire calculation. That should not be acceptable to any court. Telling a judge, we made a mistake, so now please adjust the outcome to match what we meant to say, isn't a legal remedy. It's an acknowledgement of a breach. Here's why this matters beyond just one case. If the court allows this to stand, it calls into question the entire value of a negotiated plea agreement. Imagine a family member comes to you and says they worked out a deal with prosecutors, something manageable, a few years. You've processed it, you've accepted it, they've accepted it. And then, right before sentencing, the government comes back and says, actually, we missed something. We're doubling it. And when you find out that the government didn't know, the lawyers didn't know, and probation didn't know, but your family member is still the one who pays the price, that's not justice. That's a system malfunction. If a court signs off on this, it sends a message that plea agreements are only as binding as the government decides they are, and that's a problem for everyone. So let me know what you think in the comments. Do you believe the judge will hold the government accountable and enforce the original terms? Or do you think this gets swept under the rug? Maybe you've got an angle on this we haven't considered. Drop it below.